So firstly, I'm very pleased to be here. Thank you very much. It's really nice to be here as a contingent of Queen's University. I suppose the elephant in the room here, and you'll be able to see this from my title, is that actually I don't focus on business law much at all. I teach equity interests, but I'm actually a charity lawyer. I focus on quite a lot of charity law governance. So when I was thinking about what I was going to say for this conference and what I can bring as kind of a bit of a comparative opinion, I thought I can't go into depth about various methods of business law governance as others have. But what I can do is bring my perspective from a different form of governance and the potentially limited history thereof in order to offer a form of comparison. So you might notice there that I referred to the history of charitable governance as limited. I suppose this isn't the right word to use. Charity law itself has a long history. In England and Wales, this can be dated back to 500 AD, so this is nothing new. Charity law governance is dated back to the Magna Carta in 1215. So again, charity law governance as a concept also isn't new. However, the truth is, and this is what I'm going to be focusing on today, is this idea of the charity law regulator, at least in its current form, is actually all rather recent. And that is the charity law regulator as something that isn't completely ad hoc. This is described as like inquisitive powers. So originally the charity law regulator just kind of popped in as and when it needed. And now we have, or arguably, maybe we don't, we have a bit more of a sustained active regulator. So this is most relevant, and as Matthew Taumata states in Rosemary's new book that came out last year on charity governance, the crucial time period here is actually quite recent, really. So over an 8-year period ending in 2012, Australia, England and Wales, New Zealand, Northern Ireland, Scotland, Singapore, they all established formal charity commissions as external regulators. And especially because there isn't a specific external regulator in England and Wales for businesses, I thought this was quite an interesting thing to discuss. So this means that the period of history that I'll actually be talking about is rather recent history, and that's from the 2000s. So why is that so significant and worth actually talking about? Well, I think personally, the developments from 2000 in the role of charity regulators are actually the point of charity law governance. I think will be spoken about as like the pivotal change in regulation, at least in charity law regulation, for hundreds of years to come, fingers crossed. And it pinpoints where the role of the charity regulator in England and Wales kind of brought this about. So England and Wales was the first one. It was the first in establishing a formal active charity commission in this specific way, and then the others kind of followed suit. So in addition to that, various studies have concluded that when comparing the UK, Australia and the US, that actually the efficacy of the system in England and Wales seems to be pretty good, especially when it comes to reporting regulations and that kind of governance. And that kind of surprised me. McConville and Cordery did a report about governance, charity law governance, and said that the data showed a notable difference in current reporting practices between the UK and other jurisdictions. And this isn't standalone. A lot of the different articles show that the Charity Commission for England and Wales is actually really specifically good at what it does. But this interested me because that's not really been my experience of reading about and writing about the Charity Commission in relation to my area and of charity law governance. It is this kind of regulation and governance and the development that I'll be kind of talking about today. And one thing I'd like to mention just before I discuss the systems of governance is the idea of independence. And this is probably linked to this idea of private versus charity as well, which is ingoing, at least in my own mind, but I'm sure of others too. It is important for the nature of charity, not least how it's organised through a trustee structure, for individual trustees to have discretion and freedom over the running of their individual charities in similar ways that kind of not stakeholders necessarily, but governors, etc., for a business may also have and require freedom to do so. And although the current operation of the external regulator might be considered new, this promotion of charitable independence is not, and it's certainly a balancing act that we need to weigh up. So the Charity Commission will always be treading this fine line between over-regulation and under-regulation, both of which would have significant consequences and be quite controversial in the literature. And even though studies show that the system in England and Wales is one of the most effective external charity regulators, the regulator has not always been on the correct side of this fine line. So I'm going to be talking primarily about the changes that stemmed from the Charities Act 2006. This is my favourite kind of history, 2000s history. And if you say that in front of your students, you'll realise that you're old because they weren't born. So therefore it's history. And so the Charities Act 2006 was sort of revolutionary. It provided for the establishment and functions of the Charity Commission as a standalone new operator. So this kind of stemmed from the wish for more of an active regulator rather than kind of an ad hoc system that previously, it worked for many years, but the Charities Act 2006 set out the Charity Commission's objectives. They wanted to have accountability. They wanted everyone to comply with the regulation. They wanted to keep a closer eye on charities. But specifically on the area of charity regulation, the policymakers wanted themselves to focus on. So charities that they deemed controversial are the ones that they specifically focused on when setting up this charity regulator. And they wanted to set that up in a way that meant that the Charity Commission could specifically look at those controversial charities and see if they could edit them, maybe push them out of being charities because they were in some way controversial. And Alison Dunn in 2012 described this act as representing a culmination of this policy drive for harnessing the voluntary sector, because if we had a more active regulator, we could make sure and ensure that charities were doing exactly what we wanted them to do. Because although we think of charities and we think they're all kind of soup kitchens, but that's not actually the case. A lot of them do operate more as businesses than we'd actually think. So the government wanted to reform the charity sector in particular. However, there was a specific focus on those deemed controversial, specifically fee charging charities. And my research has consistently been, for the past 5 years, been on private schools. And so I'm going to focus on that because that's my area. But for those who know charity law in some description, you'll know one of the key issues surrounding fee charging charities and the governance thereof is one particular area of charity law, which is the legal public benefit requirement. This is a requirement that all charities must meet and continue to meet in order to be validly charitable. And they require just that for a charity's purpose to benefit the public. And fee charging charities may challenge this through charging high fees, something that charity law says, no problem, you can actually charge these high fees, that's not a problem, but you can't exclude a sufficient section of the public. However, we can see from the development of the Charities Act, so this was the political persuasion, this is what kind of Tony Blair's New Labour government wanted to do and wanted to change in the form of the Charities Act 2006. They wanted to create a regulator that was active enough to actually kind of push these fee charging charities that were kind of exclusionary to quite a significant proportion of the public to do more to justify their charitable status and tax advantages, which is what it always centres on. And therefore, we've got this shiny new Charity Commission. It's the new regulator from 2006. It's got these active powers. So perhaps the new commission could not be criticised for doing just that and stepping up to the mark. And in response to the Charities Act 2006 and its new powers, an increased focus on this public benefit legal requirement, the commission set about fulfilling its legal obligation to create guidance to on public benefit, including specifically that guidance on fee charging. So this guidance, released in 2008, so a pretty quick-ish, 2 years turnaround from the Charity Commission, did just that. It required more from charities regarding their public benefit governance that had ever been before. And this was an example of the Charity Commission as regulator really stepping up and doing more, which is what the political system was requiring of it. It essentially suggested that if a charity charged high fees, it had to provide high levels of public benefit, and that the governance by the Charity Commission would be checking that in ensuring that this was carried out as well. So the guidance also gave the Commission specific powers to provide active oversight to ensure this requirement was met. Intending to improve the consistency of the public benefit provision, the Charity Commission introduced, as a form of this new governance, because it was an active regulator, it was really going to get stuck in, it created this system of public benefit oversight. So it believed that it had sufficient power to kind of minimize the independence of charities in that way, take away trustee discretion through creating this kind of system of public benefit oversight. And that was in two forms. This was a reporting requirement in the trustee annual reports, which is quite similar to the kind of annual accounts, but it included this public benefit reporting requirement from 2008. So essentially just means that charities actually have to report on what they're saying and what they've done each year to meet this public benefit requirement. Quite a low level, really. All you have to do is write a little bit about it. Most charities will automatically meet this, but this pushed fee charging charities to actually do something about if they weren't meeting it, or maybe they had to, do fee assistance, scholarships, that kind of thing. So in addition to this, addition to the trustee annual report, which the Charity Commission would also check, we also had this kind of assessments that really showed this kind of active role of the regulator, which was the public benefit assessments. And that actually meant the Charity Commission was picking a random selection of controversial charities, going in, doing, seeing the charity, doing a desk-based assessment on how they were meeting the public benefit and how they were meeting this element of this required legal public benefit requirement. And this, in charity law at least, is sort of standalone in how active the Charity Commission was in going in and actually doing something about it. Saying that, it was reasonably small scale. There was only 20 charities that it went into because they said, for lack of resources, we can't possibly do this all. But this did really show the Charity Commission to actually be doing an active job as a regulator. But obviously, like I mentioned before, with this idea of independence, in increasing these governance requirements on charities and also the oversight that the Charity Commission was placing on them, through emphasising their own role as the regulator, the Commission had kind of taken away the independence of charities and their trustees' discretion. And this proved controversial and ended up in the Upper Tribunal for England and Wales in 2012, where the Independent Schools Council, which is like a lobby group with a lot of independent schools with charitable status, they decided they didn't want to have to meet this public benefit requirement in this stringent way. So it took the Commission to the Upper Tribunal. And it found that they had limited trustee discretion too much. So they had gone too far and overemphasized their role as a regulator, because really they should just be leaving charities alone and just checking for kind of safeguarding issues. Since 2012, the Charity Commission's role has sort of settled down. They got beaten down essentially by the Upper Tribunal in saying that you have overemphasized your role here. And although they had these shiny new powers from the Charities Act 2006, in reality, this was really limited and they have been sort of put in their place. So they created new guidance in 2013 and they were like, no problem. And it really reduced the system of governance. So what system of governance do we have now? And this is very much, the Charity Commission is a very limited regulator here. We still have the trustee annual reports and the reporting requirements. But one thing I do want to emphasize is that this takes the role of the Commission as an active regulator away from it, because it's on the emphasis on the charity itself to fill out these trustee annual reports, apart from if they actually looked at them and checked for compliance, which they did in 2018, and they found that only half of charities actually demonstrated a clear understanding of their public benefit reporting requirement. And I've just done empirical work on this, and 10% of my sample didn't mention the words public benefit at all in their trustee annual reports. So it really shows the kind of limited effectiveness of governance here, but the Charity Commission won't do anything about it. That's not their problem. They have been scorned by the Upper Tribunal before. So their role has really reduced. They have certain statutory powers, problem-solving powers and deterrent powers, statutory inquiries, interim management, and they have official warnings and disqualifications for trustees. So they still have those statutory powers, but really they tend to rise from if there's been a complaint by a trustee or an external person there. So it seems now that we have this kind of cautionary effect of the Charity Commission, But in a way, although these new powers in 2006 seemed to be so new and shiny that they could really step up to the mark and really regulate these businesses, especially the ones that people deem to be more business-like, in reality, they tried that and they got stepped back down. So it's much, much more ad hoc as a regulator. I'll just finish it there, shall I?